Hey, good afternoon, everybody. Eric Boughman here. I'm joined with Kathryn Jones, and we are talking about kind of a fun topic today, social media and ethics. We have business owners and attorneys. We've got some attorney ethics in here, both related to some of the ABA material, Florida and Nevada. If you're applying for credit, hopefully it will work for technology and ethics credit. If you have questions along the way, we've got a ton of slides. I don't think we're going to get to all the material really, but it's good for you to have it for informational purposes. So if we may skip a couple, move through a few just early on pretty quickly to get into more substantive material. So with that, we're going to move forward. And if you have questions along the way, please pop them into the chat box, and we'll try to monitor that. Looking right now, very good. Okay, and off we go. So our agenda for today, we'll do a little introduction, talk about social media, what types of mediums we are looking at, talk about, primarily we're going to focus on business use and attorney ethics, and you'll see that there's a lot of overlap. A lot of attorneys are business owners or advised attorneys, and there's a lot to be learned from from attorney opinions on how to deal with sometimes difficult situations in social media that really are applicable across the board, I believe, in business. We'll touch on just some warnings for your employees' personal use of social media. And then another big topic is advertising and promotions using social media and other internet outlets, particularly using endorsements and certain disclosures that need to be made. This is really the domain of the FTC. It applies to law practices as well as to other businesses. And I have litigated in this area. It's really sort of it's starting to settle down from being the Wild West into an area that's now becoming more understood among folks that are on the internet. So social media, Kathryn, which of these are your ones? Which type of?
I do Facebook and LinkedIn. That's about it. I'm not real active on social media. I think a lot of it is generational. We kind of grew up with Facebook, but other than that, some of the stuff is new to me. How about yourself?
Facebook is primarily social. This becomes an issue when you're looking at the Florida bar for advertising purposes for attorneys. Facebook primarily social. LinkedIn primarily is business related. We do a lot of videos. YouTube, which is not listed on here, also another huge social media outlet. Obviously, we do a lot of educational stuff on YouTube. I do write on some blogs and some articles. Instagram, I think I have an account. I've never been on it. Flickr, I don't use. Review websites. Do you do reviews?
Mostly to read them. I don't really write them so much, but I think when I'm just being a consumer in the marketplace or anything, kind of where I go first is reviews to see if what I'm looking at is something that I want to invest more.
Reviews are very powerful, and I like to read around reviews. I do a lot of reviews myself because I like reviewing businesses when I have a good experience. If you get a bad review, we're going to talk a little bit on some recommendations on how to deal with that. I know that can be very problematic for people, especially because if you try to get even a false review taken down and you go to the review site, there's been a ton of litigation over that. There used to be a website, I don't see it that much, but it was, I don't remember the name of the website now. It was an old website where you could go and flame companies. Of course, Yelp has been involved in a lot of litigation. But we'll talk about the use of social media here, moving on to what companies do as far as using social media to build brand awareness. You can use it for obviously investor relations. We see tweets and updates. Somebody just sent me something this morning on a company that's getting positive publicity. Employee engagement, hiring and recruitment. LinkedIn is huge for that. And I think a lot of the folks that probably join us today may see us on a social media site. If you're using any of these, just be aware, for businesses, you may be regulated. For attorneys, you're certainly going to be regulated, especially if it's for business purposes more than social. Here's some reasons people use social media instead of regular media. Some of the reasons up here, obviously, it's a little more informal. It's more, it's less expensive. Customizable, your personalized interaction. The other thing about social media, podcasts, I don't know if that really falls into social media, but YouTube, you see stuff there. It really is, in my view, more of a democratic type environment. The big media I saw, I was listening to to some podcast or something on YouTube, and heard that every major television network except for CBS, I believe, has an executive from drug companies on their board of directors. So, when you talk about independent media, social media is a great outlet, both for news, for information, and obviously provides a mechanism for advertising as well and promotion. And risks of social media use, a lot of this is just, some of it is things that can be misinterpreted. Misrepresentations on social media can be used against companies. And then this issue of endorsements, we have social media influencers now, affiliate marketing. A lot of times people promote things on a social media site or a blog or a review site, and you're reading the reviews. It's one thing to just read reviews on TripAdvisor, on Google, and find out what other customer experiences have been. But if you are looking up, the best television sets or best computers or best law firms, there's companies out there that do reviews, and they make money for that. And a few years ago, you would see, you pull up these companies and not realize that all the hyperlinks that are in this material, people are getting paid for. And affiliate marketing is something that the FTC has been on top of. And this was one of the issues that came up in my prior litigation in this area, had to do with affiliate marketing and the failure to make proper disclosures. If you're getting paid to do reviews, or if you have endorsers out there promoting your business, and they are paid, and it may be cash, it may be some other type of compensation, maybe they're getting free goods, that needs to be disclosed. And again, this is something that the FTC has been on top of a little bit more. There's some interesting cases involving the mattresses. If anybody who's ever shopped for a mattress,
It's impossible to compare.
there are mattress
apples.
wars. Apparently,
Right.
This is a hugely lucrative area for affiliate marketing. So it's something, if you're using those avenues, they can be great for promoting business. Honest reviews are some of the best things out there, I think, for a business. But false reviews, fake reviews, paid reviews, these are the things that can get businesses into trouble, especially under either state law or federal law for false and deceptive advertising practices. So now we talk about the business use of social media and business policies. Essentially, each business, if you're using these platforms, it's a good idea to have a policy in place that the employees and your contractors are familiar with, that require business approval, and maybe designate certain people to make posts on your behalf.
My universe is mergers and acquisitions and deals, and one of the due diligence items that the buyers look at is, 1, do you have a social media policy? 2, do you enforce it? And 3, what happens if something goes wrong? What have you done to rectify a situation? So kind of looking forward in the life cycle of the business, those are all questions that you may not be thinking of in the forefront as you're going through the day-to-day operations, but those are things that come to light, when it's time to sell. So having a social media policy and enforcing it is going to be instrumental as you progress down to a sale.
That's a great point. And we also see in deals, you see oftentimes language regarding disclosures, either through press publications, social media,
Right.
Any type of disclosure regarding a transaction. We did one not long ago, and we were getting hit up with people were coming to the attorneys and asking us for comments on deal points, so they could promote it. I don't know what those companies get. I guess they just generate traffic.
They might, right?
And I'm always thinking, whenever I look at anything online, I'm always thinking, how does somebody make money doing this? Somewhere along the line, there's nothing free, so you can have your free Google Gmail account, but there is always going to be a there's always going to be a hook. There's always going to be somebody trying to make profit out of it. So have you had this? Have you had to deal with any negative experiences on social media?
Not directly. I mean, I think these points here are they're common sense, but I think people forget if they're kind of in the heat of things and they're starting to get defensive. I think the second bullet point being respectful and factual is huge. I mean, you state your facts. You state your facts, and that way, somebody, if it's true, then I think it's much easier to defend than an opinion or something that is coming out of a place of hurt or revenge. So, and just be careful when you're trying to confront people on social media. Again, it may be best just to ignore, avoid escalation by not responding.
Yeah, it's almost the additional activity that causes more attention to be focused. So I've dealt with clients who get flamed on Facebook or LinkedIn or other sites, and all of a sudden people are making negative comments. They've got their friends and family making negative comments, and they need to know how to respond to that. It's very difficult. Once that stuff's up there, it's very difficult to get it taken down. You're not going to get a third-party site to take it down because they oftentimes hide behind the Section 230 of the Communications Decency Act, which has just been totally twisted and abused. But oftentimes the best policy is at least to take a deep breath. So if you're representing a business, if you have a client who comes to you, or if we have clients who come to us and say, this happened, the first thing we want to do is we want to pause, not react right away. Definitely don't react online. Try to move the conversation offline as much as possible. And I've done that with different degrees of success, and sometimes it's just a futile effort. But feeding the dragon can almost be the worst. Worse as far as making something grow bigger and to the point where it's almost viral. All right, code of ethics. Things that you need. These are, any business, it needs to protect. Obviously, it's information, intellectual property, trade secrets, secret information about clients. There's privacy and confidentiality concerns, especially if you are, oftentimes in a regulated industry, financial, accounting, law, medical. We're gonna focus one of these seminars on medical issues particularly. Today we talk about businesses and attorneys, but you have not only protection of company property, but then also the preservation of the company's goodwill. If somebody's speaking on behalf of your business, on behalf of your law firm, if you're speaking on behalf of someone else, you need to realize that there's a bigger picture in place than just the one person who's doing the speaking. Some of this is obvious stuff here. Obviously we're not going to use social media as a platform to harass people. I also like this point here at the bottom of the slide: compliance with third-party terms of use. Understand sometimes that if you post on another website that you're subject to their terms of use. I've seen sites where, by posting information, that place where you post now has rights to your material. So if you post an article or a blog post, they can now republish that. They may have rights to use your name and your trade dress in a limited fashion. So it's a good idea to just be familiar with how your information can be repurposed and used by this company. Photos are another big one. Photos generate a lot of traffic. If photos are known to be very big for attention getting. If you're using photos, any photos you use, you should obviously have the rights of the people. And if there are people in the photos, and understand that those photos may be repurposed as well, unless you have some type of limitation on that. Business policies. Again, this should go with your code of conduct for your employees and policy for the business in general. But you don't want to use any type of and also understand that the internet and social media, while sometimes we see stuff get taken down, but sometimes this can be forever. And you don't want anything up there. It's just like the old adage, and so when you type an email, type it out and then let the email sit before you send it if you're upset. I would say the same goes for social media. Have you been in any social media battles?
Not directly. Sometimes something heats up, I'll kind of look and see how it resolves. But I try not to get into all that on a personal level. But it is, what happens is it gets entertaining. It becomes entertainment at some point where, a company and their customers are going back and forth on something, and it really just, like you said, it may, the response and the aftermath may have create bigger issues than the initial problem might have.
All right. How about protection of customers and suppliers and associates and investors? If you have information about other people in your business, either have their permission if you're going to disclose. We'll talk about that again a little bit more direct in connection with your law practice if you're going to disclose information that has to do with a client's case. But any business, you should be accurate with any information you report. Be careful not to reveal confidential information about businesses or clients or in deals that you're involved in. Again, this could go further. You could be involved in some type of M&A transaction that's subject to a non-disclosure agreement. And if you mention that, even if you mention that there's a deal in play without identifying the parties, that could cause problems. So from a business perspective, you really want to control the information that goes out and review everything. Obviously, with our firm, we do have our educational seminars that go out and get promoted every month. We do those to educate clients and other attorneys, provide CLE. But even before anything goes out publicly, that it goes through a thorough internal review. Confidential information and trade secrets. Again, this is a little bit repetitive, but want to emphasize that anything that a business puts on social media is available there for the public. Don't assume anything's going to be private. Even private messaging, if you read some of the terms and conditions with respect to certain private messages, I was never a fan of Facebook private messaging. People try to message me through that platform. I just have a distrust for anything that I don't totally understand how the information is being used. So I like a secure platform if I'm communicating with clients or with colleagues regarding any type of potentially confidential information.
I think it's more of a direct messaging than a private. That's kind of how I view those kind of messaging services that are tied to a social media platform. It's more direct, it's more one-on-one, but it's not necessarily.
That's a good point. Not private. Direct
Right.
messaging on, pardon me, versus posting something publicly. Or sometimes you have an option, even Zoom has an option where you can send a message to everybody, or you can send a message to just an individual person, but you have to assume that all of that information is going to be publicly shared unless you really do have a link or an expectation of privacy pursuant to the terms and conditions of whatever platform you're using. Did we skip one? I don't know.
No.
Okay. All right. And I think we touched a little bit on this earlier, but here's just some common confidential information that all businesses, law firms, and other businesses will run into. And you should instruct your folks working for you, your contractors, staff, employees, anybody who's doing any work for you, to be sure not to discuss this stuff without approval and permission. If somebody is doing this types of stuff for you, make sure that they understand that they're acting on behalf of the company. Go through some type of approval process. And I think we have a note on here, but I wanted to say also, what I've run into is employee leave. Somebody sets up an account. This happened more a few years ago than it does now. Somebody sets up a LinkedIn company page or a group or some type of group on Facebook, and you have an employee do it. This will happen with a small business. You have that employee set it up, and then they leave, and then they've got all the information regarding the account. And I've actually been involved in some disputes that have arisen out of that, because now the employee says, well, wait a minute, I set up this group, I set it up, not the company, and it's under my name, and I don't want to give up the login credentials. So what I do with some clients is I actually have a document that they sign. This can be incorporated into their hiring paperwork or into their independent contractor agreement, or as a separate document regarding login credentials for any email accounts and social media accounts that they use or work on behalf of the company, that requires them to acknowledge that those materials belong to the company and that they have to relinquish those at the company's request, or if they're no longer working for the company. And this is just more detail on reviewing the terms of use and terms of service for different websites and apps use them, be careful again about posting confidential information or posting things like trademark material, copyrighted materials to another platform if you don't want that stuff to be reused.
This is a big one. I think timing. If you suspect that there has been some possible infringement on your intellectual property rights as a business, or that there has been an improper disclosure, you will need to act very quickly. One of the things that, if you're in an IP litigation, for example, you have to explain why you waited so long to go after an infringement. In an M&A transaction, you may, as the seller of a business, need to make a representation and warranty that there's no infringement or nothing reasonably known or nothing that you should reasonably have known about when signing off on the documentation to sell your business. So again, timing is critical. You don't want to be in a situation where the other side can claim that you waived a defense or you kind of sat on your hands in enforcing your rights.
Yeah, that's a good point. On anytime you're seeking something besides money, injunctive relief, you run a risk by waiting. And sometimes, while we generally take the approach in our firm, and clients that I know, Kathryn and I both have this approach. I do more dealing with some of the disputes with clients. We try not to rush into litigation. This is sort of an exception to that. If your intellectual property is being infringed, then you need to move quickly, because failing to do so can be seen as a waiver of your rights. We had one interesting, we moved very fast. You can't get material taken down oftentimes, but there is an exception that I would mention in the Communications Decency Act under Section 230. There's exceptions for intellectual property. And so a few years ago, we were involved in litigation with a large social media company. It was all publicly filed litigation. And one of the issues is they had used some trademark material and individual photos of clients and clients' key personnel in violation of our clients' rights in our view. So we jumped on that right away, had an exception under Section 230, and we were moving to protect intellectual property rights and try and get the material taken down. And we were ultimately successful with that. We also unmasked a person who had set up accounts falsely. So we see that sometimes. Somebody goes in and they set up an account. They falsely represent that they are creating this on behalf of the business, but it's really a fake account. So we've seen that on LinkedIn. We've seen it on Twitter. People are making false representations, acting like they are a company or a particular business when they are not, either because they hack into your account or because they set up a false account. If somebody sets up a false account on your behalf or on behalf of your business, you need to move quickly to, in the way that usually happens, you won't know who does it. So you'll end up naming the company as a defendant in the lawsuit. You're really not going after the company. You're just trying to get them in the lawsuit for jurisdictional purposes. And oftentimes, once they realize, if you look at the terms and conditions, again, for instance, for most of these major social media companies, their terms and conditions will prohibit parties from setting up false accounts. So based on their own terms and conditions, they can't do what you're suing to get them to stop doing, which is to promote a falsely created account. But you won't know the individual oftentimes who's the bad guy or the group that's the bad people. So you sue them typically as DOE defendants. Then you use subpoena power to try and unmask those DOE defendants. That's been used at different degrees of success. Sometimes there can be criminal implications for violation of the Computer Fraud and Abuse Act, for harassment, and for oh my gosh, what's the phrase that they use now? When you are constantly following somebody on social media or following somebody, they use stalking. So we have internet stalking. Many states, including Florida, have a stalking law that can sometimes be used for these purposes. So again, it's something else. We don't have a particular slide on it, but something to be very aware of. Social media accounts, I mentioned this earlier. If you have somebody that's using accounts on your behalf, make sure they understand and everybody understands clearly that these belong to the business.
They're assets of the company. And down here at the very bottom, we've we've paper transactions where we specifically address social media accounts and in a particular business. It was very important for those to transfer over to the buyer. Like you said, Eric, you may have somebody, a staff person or somebody in an administrative capacity create these accounts and then somehow, kind of hold ransom by not relinquishing login credentials or passwords when they leave. So I think it's important just from a practical standpoint to have that documented somewhere, not rely on what the employee or whoever is setting it out to relinquish that over to you, just to have documented and have ultimate control over the account.
Yes, great points on transferring it, just like transferring a domain, transferring the control of a social media account. And where it gets dicey is that some of these social media accounts are really set up just under a person's name, even for business purposes. I don't do a lot on Facebook, but I have clients who do stuff on Facebook. Pardon me. And Facebook, you still need an individual's account to create the business information. And so there could be some confusion over whether the individual owns that account or the business owns that account. So documenting it, making sure that it's clear. All right, let's move into real fun stuff here. Ethical issues for attorneys, but if you are a non-attorney and you're watching today, don't turn off yet, because a lot of this will also apply to non-attorney business owners. The first thing we hit is some of the common ethical rules that we have to deal with as attorneys, and there's a lot to be learned here. Just duty of competence. I cite the rules here from Florida and from Nevada, and then the corresponding ABA, the American Bar Association. Those are the model rules that a lot of states follow. Notice that Nevada follows it directly, and Florida has their own numbering system. They do that for rules of evidence, for rules of civil procedure. Florida makes it confusing. Nevada makes it simple. And then there's a federal civil procedure rule, or it's actually not a rule, but the advisory committee notes talking about the use and preservation of social media with evidentiary issues. So where that comes up in Florida, we had a case a few years ago where what would happen is somebody is involved in maybe a car accident or something else, and they're posting on social media, and the attorney says, take that down or make it private, get rid of those pictures. If you're trying to pursue a lawsuit because you can't walk anymore, and you're posting your skiing photos and your surfing photos and your skydiving photos, that creates problems. Or if you're posting your drinking photos after you've just been in a car accident, so the attorneys want you to take that down. And the general rule in Florida generally is that you can instruct a client to put on privacy settings so that they restrict who can view this material, but you do have a duty to preserve that, just like any other evidence.
Eric, from a practice perspective, do you typically have something in your engagement letters on this issue, specifically just the preservation and just being careful what's posted on social media?
We don't. No, that's a good point. If it is an issue, we don't do personal injury stuff. We don't really run into situations where we are dealing with evidentiary issues on social media, because most of the clients that we're dealing with, we're telling them not to post any type of sensitive information on social media. It's usually business clients. I think where this applies more often is with individuals. It's not totally unheard of, but it's a rare business. It's going to have pictures. You see it once in a while. It usually makes big news if it's a big company and they post pictures from their drunken debauchery parties with the employees getting crazy and the management going nuts drinking shots. But our clients tend not to fall into that category. But it really does affect individuals. But you do need to be aware of it. And if it's a situation and you need to have that talk, and what I always say is, if it's a talk that we have with a client, we do want to follow it up with some type of written communication. But we do have some language in our engagement letters that does tell folks that they need to preserve documents and information and evidence. Obviously, duty of confidentiality, all the things that we talked about with protecting business information, become a big issue. If you're an attorney, you get confidential information because of your involvement with the case. And it doesn't necessarily have to be a privileged information. You could be, in typical non-disclosure and confidentiality agreements, there's a carve out and exceptions for professional advisors that include attorneys. You have information that others don't have. You may learn information about family members and friends and other individuals who are not clients of yours. Again, they're confidential, things that you learn in the course of a case. So the attorneys need to understand that the duty of confidentiality is broader than the attorney-client privilege. Pardon me. I put this note down here. I was looking at some materials, and I thought this was interesting because we talk about responding to a negative review. And what the scenario was, this is a recent Florida advisory opinion where the comment essentially accused the attorney of being a thief. I think that somebody made a post on a comment, a public review about an attorney, and said that the attorney just took the money and ran, implying that the attorney was a thief and didn't do what they promised to do. And the attorney went to the bar and wanted to respond by saying that that the court had entered an order and permitted the attorney to withdraw his counsel, which would be a public record and at first blush, yeah, factual. I wouldn't think there's anything wrong with that. Right. And what the Florida bar said in this advisory opinion was you can't say that because you might be revealing confidential information. I'm just pounding the messenger. Candidly, I'm not sure that I agree with that. I don't see what's wrong with saying that the court entered an order to permit the attorney to withdraw. If you have an order and that's entered and it's a public record and anybody can go pull that up, anybody can go online and go to it. Maybe what you do is you refer to the court file, but the bar was concerned about that. So what the bar says instead is that you can respond and say, I would like to say more, but bar rules prohibit it. I don't know how helpful that is, but we'll see that on the next slide. Here's some ways to consider responding to negative reviews. This is a big problem, I know, for attorneys. There's been some litigation over this with some of the various, especially because people just pop up these websites, and you have to understand all these people are doing it for money, right? Avo, what's the other one? There's Fine Law, I think, is one. Avo is one. Not that there's anything wrong with these sites, but when people are posting reviews on here, a lot of times, people, if they have a good experience, thankfully, I just got a good review the other day. So if that client is watching, I don't feel, but it was great. I got this great review from a client. I didn't ask for the review, but we got a nice post, and it's great to see that. Much rather see that than not see a good review. But if you get a bad review, here's some other things. We talked about this earlier. Ignore it. And maybe you want to encourage more positive reviews. As long as it's honest, you can encourage folks to make positive reviews if they had a good experience. And some firms are really, really good about that and manage that very well and have tons of good reviews. And then here's the response that the bar said was allowed in Florida, that the professional obligations don't allow me to respond as I would wish. This happened to us. We do have a bad review that I'm aware of. We have one bad review out in cyberspace land, and the person, according, whoever it was that placed the review, we still don't know. I suspect who it was, and I don't think it was a client. But under the name, we researched the issue. Actually, they had said that they complained to the Florida bar. We went to the bar. We did a public records request to find out if anybody had made any complaints. We were unable to find anything, and so our response was just we don't have any record of this person being a client or a formal client, so we have no way to respond any further, any more substantively. And it was really a one-off situation. We've talked about trying to get the website host to remove it. That's tough. If you can show that it's patently false, if you can really, but even sometimes with that, these websites, some of these sites live. I remembered that website from earlier, but I am not even going to mention the name of the website because it's such a despicable site because it just exists spaced out. It's great. This website, they allow people to go on and put bad reviews. They won't take them down, even if they know they're false. And there's been litigation on this, even if it's proven later. And they've had people who post reviews say, look, I put this up, I was upset, I was pissed off, I put the review up, but it really wasn't true, I want to take it down. They won't take it down. But they do offer their own internal dispute resolution procedure for a fee. And people, I don't know if anybody still visits that website. And this is the one that I tend to like here when I'm representing clients that have a bad review, is I try to take the communication offline. and try and get the problem resolved in one way or another. And you're going to have more luck, in my view, trying to solve the problem and get the whoever posted a negative review to remove it. Or if you know it was false and you know who posted a negative review, to remove it, maybe through legal threats, through defamation. But you're going to have more luck there than to go to the website. And then, there's still concerns about confidential info. If something was posted even by somebody, I mentioned that earlier, if they're not a client, it could be a relative or opposing counsel or somebody else. So have to be careful about revealing confidential information. This is some interesting material. Some jurisdictions will allow attorneys to respond more substantively. And then there's a few jurisdictions that will allow the attorney to reveal confidential information if there's a controversy between a lawyer and a client. Florida and Nevada do not fall into that category, but there are some jurisdictions out there that do. So if you're in another state, it might be worth taking a look at this. And I guess this arises from the notion that, if somebody makes a bar complaint about you, if a client makes a bar complaint, and you need to defend that complaint by revealing confidential information, there are certain circumstances under which you can do that. And so I suppose if the client takes it public and posts a public negative comment about you, and you can definitively refute that comment, but it requires you to share confidential information, there's some jurisdictions that say that's okay. And do you know what astroturfing is?
No. Do you?
Astroturfing is essentially buying fake or fake reviews or non-authentic reviews, having all of your friends and family go on and put reviews on. This was a few years ago, was big in New York. This has been a problem on Amazon. Sometimes now, if you read some of those reviews, you see it with books on Amazon. A book will come out and there's like, for 2 or 3 weeks, there's all these positive reviews, and then it's silent, and 3 months of no activity. In any event, both the American Bar Association prohibit this, and the FTC. So regular businesses, you can't go buy reviews, can't put fake reviews up. If you do that on a large scale, granted, a lot of our clients are smaller, they're going to fly under the radar for FTC. It could get you in trouble in the Florida Deceptive and Unfair Trade Practices Act. Competitors could come after you for unfair competition. If you are acting in a way that's considered deceptive and unfair online. But just be aware that there's FTC guidance on this, and there's the Bar Association for the attorneys. If you're going to post information, have you done any posts about cases? We did recently we were asked, but we never ended up doing something. We were asked about this deal. It was a particularly interesting deal that we worked on. Kathryn and I worked on it together, and other folks in the office. We were contacted afterwards. Naturally, we went to the client to talk about it, whether or not it was a good idea. For the attorneys, sometimes something like that, if you close a big deal for clients, it looks good.
Right.
You get a little bit of positive press. Same thing about lawsuits. Sometimes there's an interesting lawsuit. We had one. We've had a couple. The one that I talked about a couple years ago, I think, made the newspaper. The one large social media company that we sued on behalf of a client made the newspaper, and I've got another case right now with some clients that made some trade journals, medical trade journals, but not mainstream media. But if you are going to post any information about a case or a deal, you should run this all by the client, disclose to the client, and again, as you put in the bottom here, this is a good idea. No matter what business you're in, if you're a financial advisor and you're going to post information and it contains private client information, if you're a healthcare professional, I've seen these healthcare folks that post pictures like when they're in surgery. I'm not a big fan of that, but if you've gotten the required disclosures, then it's something that people are into.
I think on the deals, sometimes the parties will have their own disclosure or press release, and they may mention the attorneys, and at that point, I would reshare it or whatever, recirculate it if you wanted to kind of build off of what they've already done. But personally, I wait for the parties to come out with their press release and then follow up with a
We see
share.
litigation, you see it get used, but in the deal, in M&A type activity, new deals, oftentimes, do you see that the parties will agree or oftentimes like come up with some type of language?
Usually it's contracted for in the documents, like there may be something in the purchase and sale agreement where they have to run it by each other, or they have to, that's usually something that's negotiated ahead of time, believe it or not. So, once the parties have gone through it, I think the attorneys on each side are usually pretty comfortable about sharing it or recirculating it within their contacts.
All right, so this next slide here, we're talking about attorneys and advertising. For any non-attorneys out there, if you look at the rules of advertising you would never know this, right, from the commercials and from the billboards. But maybe it's because of the commercials and billboards. There are a plethora of rules around attorney advertising, both the ABA model rules. Nevada has them, Florida has them. I'm sure other jurisdictions do. There's one rule on misconduct. There's a rule on communication and candor to the tribunal. There's a couple of rules on confidentiality and privilege. And then there's like an entire section on advertising. And so we could do an entire seminar probably on attorney advertising on the internet. That's not what this is about today, but we do want to just make you aware that you know where to find these rules. And the issue here, and where there has been some confusion, is when is a social media profile, when is a social media post an advertisement, when is it subject to the advertising rules, when does it have to be approved? We've kind of given you a little guideline here. If it's created by an attorney and the primary purpose is to attract clients for monetary gain, and you're making offers for legal services, then it's going to look like an advertisement. But you have attorneys who, for instance, I've written. I know Kathryn's written different publications. I've written publications, for major publications. I wrote some stuff last year during a PPP for Kiplinger that was widely circulated, and that was informational. Sure, does it help my profile? I suppose it does, but I didn't. I gave the material to Kiplinger, and then they turned around and they published it the way they want to publish it. It was material that I created, but the primary goal there wasn't advertising legal services, was providing information. There was a lot of questions during COVID last year, and we were trying to answer those on a grand scale and really comment and we were really trying to steer, it was more trying to steer policy and public opinion, especially on the taxability of PPP and so forth. Communication with clients and others on social media. Again, we touched on this a little bit earlier. Same thing goes for attorneys as businesses. Here we have the comment, be careful of private messaging, which Kathryn says is in private. It's direct messaging, right. Privacy and security issues. And obviously being careful about giving legal advice. If we do an article, we do a seminar, we do these webinars, we've done some for some of the other, for educational companies. And when we do that, we're always careful to say, this is not legal advice. We're doing this for informational purposes. Hopefully, some of the folks get some continuing education credit and actually learn something that, take one or two things or two or three things away from today that you didn't know when you showed up. Look at how we're doing on time. Okay, so we did a lot of the.
Do you want to take a question?
Absolutely. Yeah. Let's see.
Okay, so we have one question here. For a business owner, can you discuss any issues with reviewing an applicant's social media as part of the hiring process? Is notifying the applicant that this will be done required or recommended?
That's a great question. I'm not aware of any restrictions on reviewing. The key for a business owner is going to be being honest and forthright. And that's the same for business owners and attorneys. So I would analogize that to the question of reviewing, and maybe on this slide or a slide here, when we're talking about an attorney reviewing profiles of potential jurors or watching the profiles of jurors before or during a trial. And what the bar rules generally say, and what the courts have said about that, is that it's okay to monitor the public profile of jurors, to both look at their profile to try and see if they have any particular leanings that would be helpful or unfavorable for your client or for your case, also to see if they make any improper disclosures during the course of trial. But what's not okay is to secretly friend them, and then by secretly friending them, find out, you get access to more information that you wouldn't have access to otherwise, or to have someone else secretly friend them. So for in the business context, I would say that it's perfectly fine and it's expected. I think now a lot of clients will ask for your social media profile, and look at LinkedIn in particular, probably look at Facebook. And then, it's up to the individuals to keep private that information that they want to keep private. What's not okay is for the business owner to either themselves or through somebody else, through a fictitious, there was a prosecutor who got in trouble for this. Actually, yeah, it's up here on the slide. Through either a fictitious creation or have one of their employees go on and friend the potential employee and then get information about them that way. That I think would cross the line, and I would advise against that. So what would you say?
I was just going to comment, and maybe a variation of this question is, if you're in a particular business, let's say you're in a regulated industry, or you're delivering sensitive, like you're in childcare or something where you're servicing a population that needs extra protection, do you have a duty? Do you have a duty to go on social media and try to figure out if there's any red flags that would be in social media that you'd have to be careful of and consider in making a hiring offer?
And that's a great point too. So maybe you take it a step further. If you do have a duty to investigate, like if you're in healthcare, childcare is a great example. We have clients that are involved in childcare, education, health, and so forth. And when you're hiring, if you're hiring folks for a sensitive position, you may make a disclosure to those folks that you are going to do a background check. It's not uncommon for employers to check credit and to do a general background check on employees, but then you want to disclose that. I wouldn't do that in the initial stage. I would say that, after, if it's somebody that you're interested in moving forward with, then you would disclose that to them. And there I could see where you would want the employee to give you access to their social media, so that you can conduct a further investigation. And really the key is being forthright, being honest about it, and not doing it in a deceptive manner. Great question. Thank you for that. All right. And I saw something up there about the astroturfing, fake reviews, astroturfing. I don't know where that comes from, but I saw the phrase and I thought, I've never seen that before. And I'm going to throw it up, see if anybody else has ever heard of it before. So if we didn't learn anything else, we learned what astroturfing is. All right. So, a couple other issues with the attorneys that are up here on the slides. Here's one. This Florida case was brutal. This attorney kept. This actually, I think the attorney got sued for the why can't I remember this word? Stalking, for internet stalking another attorney, because they kept just bashing this attorney and tagging the attorney and saying bad things about the attorney. Some of these attorneys, I hate to just say South Florida. It seems like a lot of this stuff happens in South Florida. It happens in certain practice areas. These folks are just brutal. I most of my stuff I'm involved with, I end up being friends with the attorneys afterwards, or during. But obviously you can't do this. This attorney who got sued, the court noted in a footnote this I don't even know how to, the Bacchus case here, let's call it, that the offending attorney had been disbarred by the Florida bar for this conduct that was so bad. This other case was this Ohio case where the prosecutor created fake Facebook identities to try and friend witnesses for a defendant, and that violated the ethical rules. And then, another point is don't take positions that are adverse to your client on social media. You could create a conflict issue. This can happen in a lot of different contexts. All right, so we have a few minutes. We're happy to field any other questions. Let's see, I think I want to make sure we didn't miss anything. Oh, there we go. Yes, it's an astroturfing. All right, so real quick on personal use of social media. Everybody should have, every business owner, attorney should have this policy that, make sure your employees, and oftentimes this is in a handbook or some type of communication when an employee gets hired, that your computer systems and your social, that nothing is private. They have no expectation of privacy at work. When you violate the rights of privacy of individuals, the first question that gets asked. I've done entire privacy seminars on this, and the question is always, is there an expectation of privacy? When you come into an office and you're using employers' computers, it needs to be made known to those employees that they have no expectation of privacy, that you monitor the computers, you monitor their social media activity, you monitor their web activity. By the way, don't assume that that's the case if you don't tell your employees as much, because there are court cases out there where employees have sued because it hasn't been disclosed, and courts have said, if you didn't tell them, and they've been assigned a computer, or if it's in an environment like a bring your own device to work type environment, people are working on their own laptop, but they're on the computer network of the company, if you don't disclose to them that you're monitoring, you could run into trouble for monitoring, especially if they jump on private email and so forth. Other personal use, obviously you want to make sure people don't use, you don't want people, here's another thing. I was involved in something recently where the employee was a government employee and he worked for the FDA. And this guy, I'm not going to say anything more than that. By all accounts, he was not a good person, and but there were photos of him on social media doing bad things during the day when he should have. By all accounts, I can't understand in the job that he had and what he did for this government agency, why during the day he was always putzing off doing whatever he was doing, harassing other people, and not at work. If you are a bank or you are a law firm where your offices are mostly 9 to 5, and you have an employee who everybody knows works for you, and that employee is doing weird stuff in the middle of the day, or making obscene posts or obnoxious posts, or offending, or getting into arguments with people at 1 o'clock in the afternoon on a Tuesday, that could reflect unfavorably on your business. So, just keep that in mind, that you want people to know, even if they're on their personal stuff, there are times that people are representing you. And for the attorneys out there, your staff, your contract, everybody who works for you is representing you, and you need to be aware of that. All right, so we're not going to have a lot of time to hit on the advertising and promotions, but this material in here is very valuable. And I think the takeaway here is that whenever you are a business and you're using social media for promotion and advertising, you're subject to fair advertising rules. There are the Federal Trade Commission actually has great materials on their website, particularly regarding, they have some pamphlets on working with endorsers and working with promoters. If you're working with influencers, if you're using tags, I want to kind of use a couple examples here. We have a couple. Okay. All right, I'm going to skip forward. So look at this. Here's a post here. This is what the FTC says is misleading. So it's false, misleading, false, and deceptive, or deceptive and unfair is the FTC words. Deceptive is like what it sounds. Deceptive means you're saying one thing, but really the message is something else. You're not making a proper disclosure. Unfair is where you're not telling the full story. And so they are a little bit different, and there's some different examples of deceptive and unfair. But if you look at this advertisement here that the FTC put up, you can see that the disclosures are circled in red at the bottom, and this is not a clear and conspicuous disclosure. And so the FTC has a lot of problems with this, or would have a lot of problems with this. If you have somebody out there that's speaking on your behalf, it's an influencer, blogger, something of that nature, if they're being compensated in any way, if they have an ownership interest, if they're a relative, even if it's an indirect financial interest, you need to make sure that that's disclosed at some point. And for affiliate marketing, you have to disclose if you're getting paid if you send somebody to another website. And what the FTC says, it's not in these materials, but they want that disclosure to be clear and conspicuous, and they typically like it to be in what's called above the fold. So on an internet website, if you go and you're reading reviews, they want that material to be before you have to scroll down. They don't want it to be at the bottom. So they call it above the fold. And the paper, that old newspaper, that was the front page above the fold, and on a website, it's before you have to scroll down.
I did want to mention something on the advertising and promotion slide regarding contests and lotteries.
Yes.
That's a few slides ahead. I think it's, even though, you may be trying to market and give something away, you're doing a lottery or you're giving away, you're having a contest or sweepstakes, just be mindful that each state law may be different on regulating lotteries, and they call them games of chance. So something that may be a great marketing idea and a campaign to build awareness of a brand, just run it by attorneys or anybody, if you've got in-house counsel, they're in-house people, just to make sure you're not running afoul of any kind of state law that regulates those kinds of contests.
Heavily regulated in Florida and in many other states as well. We have a couple more questions. I want to field these before we pop off here, and maybe we'll do a follow-up. If there's interest, let us know on some of the advertising, marketing, and social media. I've been involved in a couple of disputes involving this, so I've gotten a pretty good grip on it. Here we have a question. Are independent contractors on the same plane as employees? And my answer would generally be yes. You see a difference between, for purposes of using and representing a company on social media, and you want to, maybe even just as important, at least just as important, if you have an independent contract. There's a lot of folks too. You don't necessarily, you want to have an internal employee doing your social media posting and doing things online, but use a consultant. Anytime if you're hiring an influencer, it's probably not an employee, and they're going to be, if they're not an employee and you have an agreement to pay them or compensate them in some way for them making good comments and reviews about your product, they're probably going to be an independent contractor. And so yes, generally independent contractors and employees, and for investigative purposes, they may not agree to as much as far as background, but it's still recommended that you do due diligence if you're going to be hiring independent contractors. Obviously, make sure you're hiring people that are honest and fair and aren't going to get you in trouble through their comments. And also understand, if you hire those folks, or if they are acting with apparent authority, if you have worked with them and they continue to post about your company or on your behalf, even if you're not technically paying them right now, it could be conceived that you have given them apparent authority to speak on behalf of the company. And so if you do need to make a separation, that could be a dicey proposition, but you probably need to make that clear. And again, I would start that conversation offline and try not to keep it on the internet. So that, I think we've addressed all the questions for today. We didn't get through all of the material. Unfortunately, we had quite a bit, obviously, but we'll hit on some of this. We're going to do one of these directly, specifically with healthcare, because I think it's really interesting when you're talking about some of the issues that come up in that context. And if you have any other questions that come up that we didn't address today, anything you're looking at when you look at the slides and you'd like to talk about it some more, feel free to reach out to either Kathryn or myself. And that's it. Kathryn, what else? Anything else to close out?
That's it. I think we've hit a lot of material today, and feel free to drop us an email if there's anything that we didn't go over during the presentation that you'd like some more information on.
Great. Well, thank you very much. Have a great day.
Thank you. Bye-bye.